5 seconds to go. Start. Learned counsel for the appellant argued that the impugned orders are liable to be set aside because the district forums did not have the jurisdiction to entertain the complaints filed by the respondents, and the state and national commissions committed grave error by brushing aside the appellant's objections to the maintainability of the complaints. Learned counsel emphasized that the Seats Act is a special legislation enacted for regulating the quality of seats, and if the respondents had any grievance about the quality of the seats, then the only remedy available to them was to either file an application under Section 10 of the Seats Act or to approach the concerned seed inspectors for taking action under Section 19, read with Section 21 of that Act. They further argued that even if the complaints filed by the respondents under the Consumer Act are held to be maintainable, the finding recorded by the district forums that the seats sold supplied by the appellant were defective is liable to be set aside because the procedure prescribed under Section 13(1)(c) of the Consumer Act was not followed. Learned counsel relied upon Section 8 of the Arbitration and Conciliation Act 1996 and argued that in view of the arbitration clause contained in the agreements entered between the appellant and the growers, the latter could have applied for arbitration and the consumer forums should have known suited them in view of Section 8 of the Arbitration and Conciliation Act 1996. An ancillary argument made by the learned counsel is that the growers of seeds cannot be treated as consumer within the meaning of Section 2D of the Act. Learned counsel for the respondents supported the impugned orders and argued that the district forums did not commit any illegality by entertaining the complaints filed under the Consumer Act because the Seeds Act and the rules framed thereunder do not contain any provision for compensating a farmer whose crop is lost or who does not get the expected yield if the seeds sold supplied by the appellant are defective. Learned counsel submitted that the remedy available under the Consumer Act is in addition to other remedies available to a consumer, and the complaints filed by the respondents under that Act cannot be held as barred merely because they could also approach the seed inspector for taking action under Section 19, read with Section 21 of the Seeds Act. Learned counsel further argued that the growers of seeds are covered by the definition of consumer because they had agreed to undertake cultivation of seeds on behalf of the appellant for earning livelihood. On the issue of non-compliance of Section 13(1)(c) of the Consumer Act, learned counsel submitted that the district forums had rightly relied upon the reports of the court commissioners and other evidence for recording findings that the seeds sold supplied by the appellant were defective. Learned counsel emphasized that the respondents had used the entire quantity of seeds purchased by them for sowing and they had not retained samples by anticipating loss of crop or less yield. Stop.